Good morning, everyone, and welcome to all those who joined at the start of the webinar. Thank you very much for being actual. To keep us within the 1 hour mark, I will start us off officially. So welcome once again. Thank you so much for joining us. My name is Chebet Koros. I'm a research fellow here at CIPIT, and CIPIT is the Center for Intellectual Property and Information Technology Law. We say CIPIT because that's a long word. And here we are a research and training center. We're committed to producing evidence-based research and translating that research into training in the areas of intellectual property, artificial intelligence, data governance, and ICT law and policy. We also warmly welcome you to visit our website, which has a collection of our publications, resources, and our podcast called The Friendly Troll, where we unpack this research and important emerging issues. So for today, our conversation is titled Can AI Invent, which is talking about patent ownership and liability for African SMEs and startups. This is our second webinar in our ongoing IP and AI conversation series. During our last session, we explored the impact of AI on creativity. We focused on questions around copyright ownership and hearing fascinating practical insights from Mrs. Sharon Water of the Kenya Copyright Board on AI-generated works and copyright registration and how it's happening in Kenya. So you can catch up on that on our CPIT YouTube channel. But today we're turning the focus to a very important and timely question, which is, can AI be an inventor? And what does that mean for patent ownership, innovation, incentives, and liability, particularly within the African context? So looking at SMEs in Africa and Kenya, startups, and how they can navigate the evolving technological and legal landscape. To lead us through this conversation, I'm very pleased to introduce my colleague, Cynthia Nzuki, who is a research associate at CIPIT, and her work focuses on the intersection of artificial intelligence and intellectual property. And her research challenges us to rethink the traditional intellectual property concepts, considering emerging technologies. And I'm sure today's conversation is going to be insightful and thought-provoking. So please help me join me in warmly welcoming Cynthia Nzuki.
Okay. Good morning, everyone. Thank you so much, Trevette, for the welcoming remarks and for that introduction. As told, my name is Cynthia. I am a research associate here at CIPIT. And yeah, I am looking forward to the conversation today. We do have someone joining us who has experience on the ground and how things are. But before we get to interact with him, I'd like to share a brief presentation on the topic for the day, which is, can AI invent? At this point, there's a poll that should be going up, introducing us. So the poll is asking you guys, who do you think owns an invention created with the help of artificial intelligence? Do you think it's the AI programmer? Do you think it's the company or individual using the AI system? Or would you say it's the AI itself? I'll give us a few minutes to cast our votes. I really am curious to see what your answers are. Yeah, so who do you think owns an invention created with the help of AI? Okay, I think we can see the results now, if that's possible. Oh, interesting. So we have 72% of you saying that the company or individual using the AI system is the one who owns the invention created, while 22% are saying that it is the AI programmer, and then 6%, which is two out of 32 votes, saying that it's the AI itself. And we have another comment in the chat from Emmanuel saying that he guesses that it should be co-owned. So those are all very, I think I'm really interested in the way of thinking for those who selected the second choice. And it is with that then that we get into our presentation today. And as AI becomes increasingly embedded in innovation processes, this question that we have asked is no longer hypothetical, particularly for African startups and SMEs who are seeking to build valuable and commercially defensible intellectual property portfolios. So in today's IP conversation, as stated, we will look at the question of, can AI invent? New, useful, and unobvious inventions are protected by patents. So when we look at patent protection, the criteria to meet is that which you're seeking protection for ought to be new and completely novel, which means that it hasn't been there before. It needs to be useful, which means that it needs to have use, industrially applicable use, and that it should be a non-obvious invention, meaning that if given to another person of the same skill, they wouldn't anticipate the invention. And these inventions are protected by patents, which grant inventors exclusive rights over their inventions for a limited period of time. In Kenya, it's 20 years, but it could vary from different jurisdictions. So patent law was designed around human creativity and not autonomous systems capable of generating technical solutions with minimal human input. The debate on whether AI can invent gained global attention through the DABAS patent applications. So the DABAS invention, are related to a food container that involved interlocking food containers. So DABAS, which is short for Device for the Autonomous Bootstrapping of Unified Sentiments, yes, was designed to generate novel ideas without direct human intervention. So it was a system that was built to do this thing on its own. Patent applications were filed in multiple jurisdictions, and the person who was filing listed DABAS, who is not a human, as the inventor, and the machine's owner, known as Stephen Thaler, as the patent owner. So the applications triggered a series of legal challenges in jurisdictions, including the United Kingdom, the United States, the European Patent Office, and other jurisdictions such as Australia and South Africa. So the overwhelming majority of these jurisdictions rejected the application on the basis that an inventor must be a natural person. A natural person is a human being, yeah? And an exception emerged in South Africa, however, where the patent listing, the patent that was filed, the patent application that was filed listing DABAS as an inventor was granted. This, however, this outcome, however, was widely interpreted as a function of the country's formal non-substantive examination system, rather than a definitive endorsement of AI inventorship. So what does this mean? In South Africa, the patent was able to pass and they were able to get patent protection because their system was more formal, like the examination process was more formal than it was what's the word again? Substantive. So in it, they looked like if they looked at if you have already submitted what is required, then you pass and go through. So for African innovators, the implications are practical and immediate. As startups and SMEs increasingly rely on AI tools in product development, unresolved questions around inventorship, ownership, and liability may shape investment decisions, commercialization strategies, and the future competitiveness of the continent's digital economy. So at this point, I'd like us to look at AI assisted versus AI generated inventions. A useful distinction in this discussion, as we have begun, is between that of AI assisted and AI generated inventions. So in AI-assisted inventions, humans remain at the center of the inventive process, using AI as a tool to support research, design, and problem solving. So for example, take a pharmaceutical researcher who may use AI to analyze large data sets and identify potential drug compounds, but the researcher still directs the process and makes the key inventive decisions. On the other hand, we have AI-generated inventions. So these ones go a step further. Here, an AI system produces a technical solution with little human input beyond setting the system in motion. So these, as pointed out earlier, raises difficult legal questions, such as if the AI did generate the invention, then who should legally qualify as the inventor? So I'd like to take us on a brief crash course on what is needed to get a patent. So to obtain a patent, an invention must generally meet three core legal requirements, as shared and discussed above, which are one, it should be novel, so there's the novelty requirement. Two, there should be an inventive step, which is, it shouldn't be obvious, but it's also known as non-obviousness test. And three, it should be industrially applicable. In other words, the invention must be new. It needs to be not obvious to someone skilled in the relevant field, and capable of being made or used in an industry. Yeah. So AI introduces new tensions into the patent application process, particularly around disclosure and inventorship. Patent systems still require applicants to identify human inventors and explain how an invention was developed. So when you put in a patent application, there's a part that is known as a claim. Under the claim is what you give details to the registrar and the patent examiner as to what it is that you are requesting or are applying for patent protection for. So where AI systems play a significant role in generating technical solutions, it becomes more difficult to determine what level of human contribution is enough to justify that inventorship. And again, this creates so many uncertainties for inventors and innovators who use AI tools, because then now they start asking the questions of how much reliance on AI is too much, and how should that contribution be disclosed within the existing patent frameworks. Current patent systems, including Kenya's, are still building around the assumption that inventors are human. As it stands right now in our law, the recognition, in our law, I mean the Kenyan law, the recognition is of humans as inventors. But as AI systems become more involved in generating technical solutions, that assumption is becoming harder to apply in practice. So for startups and SMEs, this uncertainty creates real commercial risks, because then now you have to deal with having to see how to prove human contribution, which may affect the patent validity. You have to start thinking about investment negotiations, the long-term value of an innovation asset. It has more questions and more liabilities because at the moment we still don't know where we stand. So as we get into the next part of our conversation today, AI is challenging traditional assumptions in patent law, particularly around inventorship, ownership. So questions such as whether AI can be recognized as an inventor and how to allocate rights where AI plays a significant role in innovation do remain unresolved under existing legal frameworks. That, however, does not mean that conversations around it are not happening. This is one of them that we're having today. So these uncertainties do have real implications for for people who are using AI out there, and it does affect how innovation can and will be protected and commercialized. So as we go into the next part of our conversation today, we are privileged to have one Fred Otmongo, who is a patent agent and technology transfer officer. Mr. Fred Otmongo is the university patent agent and technology transfer officer and adjunct lecturer at the School of Pure and Applied Sciences in Meru University. Yes. He is a registered patent agent and former patent examiner with the Kenya Industrial Property Institute, also known as KIPI. And Fred has over 20 years of experience in intellectual property management and commercialization. He has led successful licensing negotiations across various technology fields. And we're really privileged to have you, Mr. Fred, joining us today. And karibu sana. And we would like to pick your brain a bit more on this conversation. I hope, yes, karibu sana. And to start us off in this conversation, I'd like to ask you this question. From your experience, first as a former KP patent examiner, and currently as a patent agent and technology transfer officer, how would you say AI is changing the way patent applications are assessed in practice here in Kenya?
Thank you, Cynthia. I'm actually privileged to share my experience with the team here. I'm happy. You've actually said it all. But having wore two hats, one as a patent examiner and now technology transfer officer, I want to maybe share, agree, first of all, that AI has helped in assessment of patent examination. It has helped examiners on a positive note to be able to evaluate. Now, during our days, there was no AI. Of course, up to 2013, the AI was minimal. We were not using AI. So we had a lot of issues assessing a patent application. But today, I am sure, and I think I've also experienced that, the patent examiners utilize AI in prior art search. You remember, just like you've said, that a patent application is subjected to international search to ascertain whether the claims are novel, are new, or they are not. So they do this by checking on what has been published before. And you can imagine if you compare manual search with the current search online using AI, definitely the AI one will be faster. So I need to say that the examiners today are using AI tools to scan through global databases, and this happens instantly. They are able to discover hidden prior art documents in multiples, things that could not happen before. This is an advantage to examiner because it means then within minutes or within hours, is able to produce a search report. I remember in our days, I think patent search was, to me, used to take longer than even patent examination. Because you take claim one and then you subject it to international search, then you discover one or two prior art. So when you think that you are there, you take another 1 hour and you try another search. You discover so many that are again related to that. So your report is definitely defined. So on a prior art search, I think AI is a plus to examiners. They are able to use that to be able to discover. Of course, with some problems, it's likely to over-discover and confuse the same examiner. But on a positive note, it's helping patent search. Two, the examiner are subjected to classify the application. In our days, if an application or the subject matter has 2 or 3 issues that are related, maybe it has a process together with a product. We used to have issues that where do we classify this application and so on. But today, I think AI tools has contributed to the efficiency in classification. Because I imagine if they subjected the claims to an automated system, it's able to narrow down to the closest category of the patent classification. And when the search is done and the application is classified, then that helps in terms of speed. So maybe we should say there is no reason why an application should take 1 year to examine like our days. It should be shorter than that. And this question of 18 months before publication, I think the whole world needs to consider that and bring it down because AI has contributed a lot on that. Now, what happens then on the subject matter? Because when you're doing manually, the subject matter in the claims or in the patent application may be a bit ambiguous because of the time required, because of the issues involved. Now, when you are using AI, definitely you will be able to get to it faster. But now, how about if the application itself involves AI? Like what Cindy has actually put, 2 types, one AI-assisted inventions. Of course, that one is more or less clear because the examiner then will be able to get to the subject matter. But when AI, the invention is generated by AI, most part of it, because you can tell this from the literature. If there is some disconnect, then it means the writer was not even sure what the subject matter was. So if the subject matter is more AI generated, then the examiner will definitely jump to Section 21 of the Industrial Property Act and may put aside the invention, arguing that it is it's more or less like a computer generated or guided or a software, more or less. So it's because of the same AI that eligibility has been exposed. It's very easy. You put the same AI into the AI system to do a search or examination, then it comes and reveals the exact source. So you realize then that is good enough. They kill themselves in that way. So it exposes the subject matter and it's likely to be suicidal, especially if it directs the examiner to Section 21. Now, finally, on the same section, there is this, what we refer to as limited skills in use of AI as examiners. And because of that, I think, I don't want to say lack of capacity, but there is need now to continue retraining the examiners on how to use AI wisely during patent search and patent examination, so that they don't overdo and to the disadvantage of the inventor. So generally, AI has helped examiners, but it has again more or less contributed to the failure of some inventions that are related to ICT through that exposure. So examiner improving on their skills on how to use AI is very important. So thank you very much, Cynthia.
Thank you, Mr. Fred. And I think it's interesting that you highlighted at an examination level, AI, the use of AI has made examination more efficient, especially when looking at novelty. So I would like to ask you whether you think the current patent framework we have is sufficient to deal with AI-related inventions, be it AI assisted or AI generated. You've highlighted Section 21 of the Industrial Property Act, do you think there are practical gaps that are creating challenges for innovators and institutions? And what could a change look like in order to deal with AI-related inventions?
Yeah, thank you once more. Definitely there are gaps, because you can imagine the act was established in 2001. I think when AI was just coming up, I guess it did not incorporate, not even anticipate AI-generated inventions coming up. So the first gap is what you alluded to early, and this is the human element. We appreciate, and I think most of us, especially the Gen Z and those who have been in class, most students now resort to AI rather than the lecturer notes. So the AI is actually a friend to most people who are in school or those who are doing research and all that. So because AI is smarter than us, we've agreed, although we are better than AI in terms of memory. We remember things longer than AI, but AI makes decisions faster than us. So because of lack of or insisting on human element for you to be an inventor, that's already a very big gap. Because of, I don't want to say human rights or whatever, it's actually unfair to claim as an inventor when you know very well that the inventor is actually the toolbox, the machine. So that is a very big gap. And I don't know how lawyers will address that. But I would pray that at one point we need to decide and say, look, if the invention, the degree of contribution by AI is higher than the human, if there are two subjects there, one is the human who is being assisted and the other one is the machine. If the percentage is higher than 50%, contributed by AI is higher than 50%, that invention should not belong to the inventor. Maybe examiner should reject and throw it back to the public so that it is free for all. People use it for free. Alternatively, they should put a percentage and say, okay, the owner of the machine should get a percentage, a reasonable percentage, and the rest should go to the government. So it should be patented, yes, as a public good for the country, but knowing very well that the benefit should not go to the inventor 100%. So that issue of human element is very important. The second element that is a big gap is sufficient disclosure. You remember one of the requirements for patentability or for an application to qualify a patent is disclosure. If you have not disclosed fully what you want to patent, then the examiner may reject your application. Now, the sufficient disclosure is determined by a person skilled in the art. Now we are getting challenges here. There is this gap where now AI is more skilled in the art than the human beings. So if AI that you are subjecting to is more skilled than the examiner himself, then that is a problem again, which needs to be addressed as a gap. So maybe the level of disclosure need to be either raised or reduced a little bit so that the examiner and people who are skilled in the art are able to cope with the AI standard. Just quick one, I know taking longer here, but there are issues here. It's you who brought the question, the gaps. There is this gap of inventive step. I know that a patent must involve an inventive step. It should not be obvious. Now, you can imagine before, in our days, we could subject application to manual. When you interrogate it manually, it's very easy to achieve non-obviousness or to achieve the inventive step because your degree of access is limited. Now today, when you subject those claims to to search and you are examining, AI will run through millions of prior art. And within seconds, it has interacted with them and it gives you the results. Maybe you're querying, sir, do you think this application is obvious to those skilled in the art? It will definitely tell you, yes, this is an obvious one. Because it will go through, it will interpret in its own way. And God forbid if it gets to the exact open source where the invention was sourced. It will be able now to say, look, it's obvious. But then the question is obvious to who? So if you and all the professors in that field have been consulted and they say, no, this is not obvious, this is very unique, and we agree, AI will definitely challenge that. So this gap, the issue of the interpretation and the definition of inventive step needs to be relooked at, because there is a gap there now that AI is able to almost reject all patents based on obviousness, because it will definitely interpret. Of course, it can misinterpret if you rely on it seriously and try to suggest that it's obvious when it's not. So the next gap that I see is the university institutional gap. This is the university, the technical institutions, and the research institution do not have intellectual property policy that translates or interprets what is open source AI versus the normal proprietary models. If you look at those policies, most of them do not address the issue of AI. They don't address the issue of open source. If an invention has relied on open source and some value has been added and a student or a faculty is presenting that application to the technology transfer office to be patented, what happens? So that institutional gap needs to be repaired or refilled by reviewing the IP policies to be able to talk to the current situation of AI versus the intellectual property in terms of ownership, in terms of how much to generate, and in terms of disclosure, so that it's very clear from the TTO's office before the application is presented to KIPI and any other IP policy. Finally, there is this issue of how do you then enforce? How do you enforce an application that is AI generated? How do you enforce? Or how do you ensure that AI will not infringe on your application? Because definitely AI will generate from somewhere. And it doesn't know, it hasn't been told properly that, please, if you find a valid patent, don't steal, don't infringe on that. Don't pick that knowledge and bring it to my patent application. It's not able to interpret properly that this knowledge is now in public domain and this one is still under protection. So the enforcement hurdles have come up. It's a very big gap because of AI. You present your application very sincerely, but you don't know that it has already infringed. So when that is done, who bears the cost? Because I don't think you can sue AI for having misled you. So this is a gap that both institution and government needs to look at. Thank you, Cynthia.
Thank you so much, Mr. Fred. And I find the points that you have raised to be very important. There's still questions that we have that require answers, and more so to that last point on enforcement, because who then do you ask questions where infringement happens? Shifting to your current expertise as a technology transfer officer, I'd like to ask you how is AI involvement in innovation affecting questions of ownership and commercialization? You've spoken a bit on the enforcement part, and a bit on the question of ownership. Maybe you can touch on the commercialization aspect of this question.
Yeah, thank you, Cynthia. Now AI plays a major role. We've agreed in generating IP, helping to innovate and so on. But we understand that the main aim of protecting or at least patenting your idea is to commercialize. So the issue of ownership, which will eventually lead to commercialization or during commercialization, is definitely thorny here because, as we have mentioned, the Kenyan law does not recognize non-human as inventors. And therefore, it will be equally difficult to recognize AI as the owner or even the applicant of the patent. It cannot even be a co-applicant of the patent. So this has brought a vacuum in there because if you are the owner, then you have full right on what is there, and you are the one to monitor to ensure that infringement does not happen. Your secret co-partner or co-owner, the AI, maybe it's not aware about that. And that's why it's directly linked to even leaking your know-how to other people. So there is that issue that we need to redefine the ownership in terms of commercialization. Who is the owner of the IP when AI has contributed more than the inventor, or when AI has helped you? So that needs to be redefined very well. Now, there is joint owner disputes, which is likely to occur, especially if you are having a software developer together with the person or an individual providing data, and definitely a university researcher, for example, or the inventor himself. So maybe data provider is the AI, then the developer is the human being, and then the developer has also used the AI to do all that. The researchers use the same AI to do the basic research. So there is definitely a likelihood of a dispute during commercialization on who is the really owner. If, for example, the university has a particular percentage that they normally give to the inventor, who could be the software developer. The software developer has done his best, of course, assisted by the AI. So during commercialization, chances of having disputes on who is the really owner and how much do you own is likely to come up. Now, the issue of NDA, we all know that during commercialization, I think one of the first elements is confidentiality. And then there is this NDA where parties sign that, okay, I'm not going to share, I'm not going to disclose information and all that. But then the information that has been involved in generating this is online already with the AI, Mr. AI, who is ready to share with Tom and Dick out there. So there are this risk of accusing each other during commercialization that we think it's you who has leaked information to our competitors. We think it's you who has done ABCD. So there are those hidden risks on implementation of NDA. NDA is very difficult to implement today because of subject or because of exposure to AI. Now, valuation is also ambiguous during commercialization because you can value your innovation theoretically using the market value where you are, of course, but try to subject that valuation to AI. You'll get very interesting results Now, those results have been given to you through calculation that you are not aware of. So 2 or 3 negotiations that we have gone to, our team has used AI to try and value. We were valuing Mira, and then we got very good results, but we were challenged during discussion. Can you give us the calculation how you arrived at this, all that? So that was a bit difficulty. So it's a two-sided coin. AI has contributed to easy valuation and negotiation of the technology, but then at the same time, it has brought in risks and ambiguity in terms of finally, Cynthia is on the contracts. When you're doing licensing contracts that involve some AI generated information, a bit tricky. Maybe I should just say it's very difficult to fully implement those contracts because of the black box. So thank you very much, I think, for that.
Well, thank you so much, Mr. Fred. I think I'll ask you 2 last questions, one from my end and one that I saw earlier in the chat before you give us your parting shot and we wind up on this conversation. And this question is asking, from your experience, have you had any situations of dealing with AI-assisted or AI-generated inventions coming to you? And if yes, how have you maneuvered it? Yeah, you can share with us a bit from the experience.
Yeah, thank you very much. Yeah, I have on several occasions, because you see, we are dealing with students and we're doing PhD masters at JQuat, the same story, and Meru, a bit of Masinde Muliro too. You know, we have this what we call the hackathons coming up, and the students from engineering class and the ICT have discovered that is a hot cake. So they work on them very fast. They go to open source and get very good innovations. And for sure, they are new. They are new in Kenya and they do marvelous jobs. The issue is we assess before we do a patent application. So when we subject assessment of the invention, we realize, oh, AI has contributed much more than the inventor who has presented it to us. But again, because of integrity and ethics, you cannot tell that inventor. You can't, you can't say, oh, the young man, this is not yours. So we let it go. We let it go. So we have more than once returned the invention, the application to the inventor, and asked them to proceed as individuals. I just don't know whether they go to KIPI or they implement directly on their own. A few that we have managed to take, KIPI has also challenged us, but we've been able to secure. So I should say, out of 10, I think we have 3 to 4 utility model applications. Of course, we don't go to the full patent. We use minor patent, which does not require the obviousness. So we have been able to file and secure patent certificates on a few inventions that are AI. I should not say generated, AI assisted. Yeah, we have. Thank you.
Thank you, Mr. Fred. The last question I'll ask you was submitted by one of our participants early on, and this is from George Kihara. He asks, when patents or products appear similar and there is a possibility of bias in assessing the comparison, should the determination of the infringement be based strictly on the patent claim rather than on perceived similarity? And finally, they ask, how are we going to disqualify bias? I can repeat it.
Okay.
Or have you gotten it?
Yeah, but you can repeat. You got it.
Okay, so If you've got anything, you can proceed and answer.
Yeah, I think the gist here is that if there is bias based on the similarity, and then bias based on the claims. I want to take it that the similarity here is the product. The product is already maybe in the market, and the claim is at the legal level, the technical bit, when the application is being described. We understand very well. I think, in my view, the infringement here, the dispute should be based on what was claimed, and not the similarity, because similarity may mislead a little bit. But what was claimed is more important. I'll give a very simple example, maybe not on AI, but on tea, preparation of tea. If I'm claiming that my method of making tea has got 3 steps, and these steps, of course, are sequential as follows. I boil water first, then I put tea leaves. When the tea leaves boil, then I add milk. So you see it's boiling at a certain temperature, then tea milk. Your method, another different method, similar, but you are claiming you start with milk. So when the milk boils, then you add tea leaves. When the tea leaves are done, then you add water. So the 2 methods are different. So they can be in the market, but the product is similar. Definitely, the person who went to the market first will say, look, this guy is selling my tea. When they go to court, the court should look at the claims, not the similarity. So hope that answers the question, Cynthia.
Yes, I believe it does.
Yeah.
I'd like for you to give us your parting shot and your closing remarks when we come to thinking about whether AI can invent. What would you close off this conversation with?
Yeah, I know I had alluded to it, but now I think AI is a tool. We all need to be assisted by AI. We need to not to shy away from AI, because I've heard complaint AI is coming in to replace the inventors. AI is a tool that should be used by everybody. But as I mentioned earlier, we need to recognize its contribution. I know it has no feelings, but at some level, ethically, we need to amend our laws, or actually redraft the patent laws, to be able to recognize that AI has a contribution, and see how we can have that contribution for the public good. The other element, as a parting shot, is to the patent examiners, to encourage them to continue using AI, but very carefully, because AI can equally mislead them during the final decision, leading to unfair rejection or undue delay of the patent examination. So combine your expertise with the AI before you arrive at the final decision on the fate of patent application. Thank you very much.
Thank you very much, Mr. Fred, for your time, for your knowledge, for answering our questions. I know there are more, but we are running out of time. For me, I'd also like to say thank you to the participants for joining us. I'd like to turn it over to Chevette to give us the closing remarks. I want to say thank you for coming. I too have learned quite a bit. Yes, thank you. Over to you, Chevette.
Thank you so much, Cynthia. Thank you so much, Fred. It's been an extremely insightful discussion. Some of the participants have put that in the chat, and I echo what they're saying. I've learned a lot as well, getting the insights from how things used to happen before and how things are happening now with AI. It's very interesting. And I'm very curious if we've changed anybody's mind, if we can have that same poll we started with, up, come back up, in just a few more minutes before we close up. Don't rush out. We still have you for 6 more minutes. The poll is up. The question which was asked is, who do you think owns an invention created with the help of artificial intelligence? Is it the AI programmer, the company or individual using the AI system, or the AI itself? I'm very curious to see whether we have changed anyone's mind, or we have the same percentage as we started with. I'll just give you 1 more minute. Put in your thoughts there, then we can see if things have changed after we've gotten the wonderful presentation and conversation from Cynthia and Fred. Okay, let's see the results. Oh, okay, we're still at the same place, but it seems that a few more people have gone to the second response, which is quite interesting. So thank you very much for everyone who has joined us. Today's conversation has shown us just how the intersection of artificial intelligence and intellectual property is raising urgent questions. And these are not just fundamental theoretical questions, as we've heard from Fred, his experienced students who are coming and they're talking about this thing. And today we've just really scratched the surface and talked about the intersection of patents and utility models, but in a very high level way. So if you're interested in going deeper, CPIT will soon be launching an AI and IP masterclass, which is a deeper dive into today's themes. And beyond that, it's going to be covering issues about copyright and generative AI and patents, utility models, data governance, and AI regulation, among other topics. So if you're interested in joining that, please either scan the QR code or in the chat, we should have a link for you to go straight to the form. It's a very quick form. But also, if you fill it, then you'll be one of the few people, or rather among the first people to know when the registration is open. So again, thank you so much for joining us today. We look forward to seeing you at our next conversation and hopefully at our masterclass. Thank you so much for all your contributions, your questions which have come in through the chat. And you've really helped us to grow this conversation. And we look forward to having more conversations with you. Feel free to reach out to us from on our website, through our social media pages, and to continue with the conversation. I only ask for 1 hour of your time and I want to respect your time. So with that, we shall end our webinar today. Thank you very much.